5 and 5, 4. Okay. This is zoning. Here's the introduction. It involves a historical background, the Garden Cities of Tomorrow by Howard in 1898-1902 time frame. And he was a proponent of the Industrial Revolution, and zoning to him solved the problem of externalities in environment where bargaining, servitudes, or judicial determinations were found. And nuisance law was not sufficient. So nuisance and servitude doctrine, in parentheses, I've written restrictive covenants, fall short of effective means to protect harmful effects of advancement to the neighborhood. So nuisance and covenant law proven ill-suited to control growth of the cities. And so that's the origin of zoning law. Only worked for individual or individual planned communities. An example we're giving is the Neponset case again. City planning development over time. City planners needed a way to apply principles contained in nuisance and covenant law to entire area. Standard State Zoning Enabling Act, which is SSZEA, I think, or SZEA of 1925. And what I'm also writing is that the Supreme Court of the United States answers whether new controls amounted to takings of property without just compensation or work deprivations of property without due process of law by permitting Euclid zoning. And what is Euclid zoning? It's cumulative height zones, use zones, and area zones. So the next case, not surprisingly, is the Village of Euclid versus Ambler Realty Co. Introduced Euclidean zoning, higher use residential to lower use commercial scale. This represents a constitutional zoning scheme that requires no compensation under the takings clause. And I've got the procedural context here. Ultimately, the zoning law was upheld, and the court used the rational basis test. What would be the effect of a restraint imposed by one or more of the innumerable provisions of the ordinance considered apart upon the value of marketability of the lands is neither disclosed by the bill nor by the evidence, and we are afforded no basis apart from mere speculation upon which to rest a conclusion that it or they would have any appreciable effect upon these matters. The issue in the holding, it's pretty long, but I wrote SCOTUS, in the margin I wrote SCOTUS leaves open an as applied challenge because too difficult to examine a facial challenge. So just reading the holding is, where the equitable remedy of injunction is sought as it is here, not upon the ground of a present infringement or denial of a specific right or of a particular injury in process of actual execution, but upon the broad ground that the mere existence and threatened enforcement of the ordinance by materially and adversely affecting values and curtailing the opportunities of the market constitute a present and irreparable injury. The court will not scrutinize its provisions sentence by sentence to ascertain by a process of piecemeal dissection whether there may be here and there provisions of a minor character or relating to matters of administration or not shown to contribute to the injury complained of, which, if attacked separately, might not withstand the test of constitutionality. So I guess that's why the margin says that they're leaving open an as-applied challenge. Because it would be too difficult to rule them all out in one case. So Euclidean Euclidean zoning, also called cumulative zoning, because higher use is permitted in lower use zones, but lower use is not permitted in higher use zones. Note higher and lower uses refers to social desirability, not monetary value. Land may be more valuable for industrial or commercial use than for residential use, but residential use considered a higher use. We're citing the Euclid case. The city separated into 6 use zones, U1 through U6, 3 height zones, height 1 to height 3, and 4 area zones, A1 through A4. Use zones classify what types of buildings or uses can be built. U1 is single-family home, U2 is multifamily home, U3 is apartment, houses, hotels, churches, and U4. Probably something like industrial, but nothing's written here. Historical FDR New Deal era substantial due process to strike social legislation by way of 4 horsemen, but Sutherland supported zoning. So that's kind of the policy background, if you can dissect what that or discern what that means. Case Moore versus the City of East Cleveland marked a change. Example, takings from PA Coal Company versus Mahan, which is 1922 in Pennsylvania, relating to excavating coal. And another case example is Necto versus City of Cambridge in 1928. Zoning can neither be arbitrary or unreasonable. Houston practiced exclusionary zoning, and the structure of authority underlying zoning, the enabling legislature per the police power. California, New Jersey, and PA state zoning laws deviate much from SSZA. SSZA regulate and restrict the height, number of stories, and size of buildings and other structures, and land for trade, industry, residence, or other purposes. Create districts comprised of differing zones, if made in accordance with the comprehensive plan, and designed to reduce congestion in the streets, to secure safety from fire, panic, and other dangers, to promote health and the general welfare, to provide adequate light and air, to prevent the crowding of land, to avoid undue concentration of population, to facilitate the adequate provision of police power, safety, healthy morals, transport, water, sewage, schools, parks, and other public requirements. Considers character of the district and its peculiar suitability for particular uses, and with a view to conserving the value of buildings and encouraging the most appropriate use of land throughout the municipality. SSZA requires the mayor to appoint a zoning commission to do the following: grant variance for practical difficulty or hardship to comply, to create ordinance, Board of Appeals, modify ordinance, variance, special exceptions. See the City of Brunswick. I've kind of crossed out some notes in the margin there. Next section is titled The Comprehensive Plan, Statement of a Local Government Objectives and Standards for Development, Master Plan, including a map and bounds and details. Mount Vernon, monopoly zoning, S&D to increase home prices, alt controls from zoning, so alternative controls not including zoning or from zoning is subdivision, environmental review, developer fees, adjoining streets, parks, roads, amenities, economic efficiency, zoning to minimize negative externalities, or provide zoning to maximize positive externalities, and absent land use regulation, the land would go to the highest and best use. So the next large section within zoning is non-conforming uses, and the case on point is Pennsylvania Northwestern Distributors, Inc., versus Zoning Hearing Board of 1991. Amortization period for correction of non-conforming use is 1, majority legal if reasonable, or 2, minority completely disallowed, and requires uses that are older than recent zoning laws to be grandfathered. And procedural context, this is starting with the Court of Common Pleas in Allegheny County, 1987. The judge dismissed the appeal. The owner appealed to the Commonwealth Court, who affirmed, obviously, the dismissal. And then the Supreme Court, where the owner petitioned for allowance of appeal, the Supreme Court opinion, Justice Larson in 1989, identified an issue: does ordinance constitute a taking, which requires just compensation, to the following facts. Of an adult bookstore was legal when it was open, but an ordinance was placed amending the ordinance that restricted adult bookstores from that location, which rendered the owner's use to be non-conforming. The owner challenged the zoning board ordinance, which required 90 days compliance, in parentheses, that's amortization, and could not bring into compliance the store without closing the business. The use in accordance with use restriction, amortization, and discontinuance of property's lawful pre-existing non-conforming use, the zoning hearing board upheld validity of ordinance and causing the owner to appeal multiple times to get to the Supreme Court. Their opinion analysis included case law in which Sullivan set the standard, considers the length of the amortization period, the nature of the use, the relevant facts and circumstances, the benefits to the community, offset of losses, and a lawful non-conforming use establishes in the property owner a vested property right which cannot be abrogated or destroyed unless it is a nuisance, it is abandoned, or it is extinguished by eminent domain. The rule in the minority of jurisdictions is that amortization is constitutionally a taking subject to just compensation, whereas the minority sees amortization as a reasonable exercise of police power and does not violate due process or the takings clause, which requires just compensation. So the holding in this case is that an amortization provision of zoning ordinance was unconstitutional on its face since it took property without just compensation, and non-conforming uses must be allowed forever, and amortization of non-conforming uses are unconstitutional takings without just compensation. Conclusion, this was reversed for the owner, in favor of the owner. Example, Rudolph Steiner Fellowship Foundation versus DeLucia, non-conforming use that cannot change to a use that is also non-conforming but of a character less offensive to zone. Example, in Paxinosa Ave would allow a shift from one non-conforming use to a less than or lesser something. Destruction of non-conforming use. Act of God will usually terminate an use of not conforming use of not more intense, i.e. traffic. What am I talking about? Destruction of a non-conforming use. An act of God will usually terminate a non-conforming use. Example, sale, non-conforming use right does run with the land as long as use is not more intense or traffic. Might be what that says. Abandonment of non-conforming use, same as destruction, 2 years. Common law common for abandonment to reduce legislative intent. Mothballing, in parentheses or in quotations, example, Lundy's. Example, Toys R Us versus Silva, 1996. Partial discontinuance will suffice for abandonment. Example, Caher Enterprises versus Zoning Board of Appeals of Provincetown, 1997. Stokes versus Board of Permit Appeals, San Francisco Gay Bathhouse changed to homeless shelter in AIDS crisis, and that constituted a discontinuance of the non-conforming use. Example, Duffy versus Milder required for zoning change leads to manifest intent to abandon use. a request for a zoning change leads to a manifest intent to abandon use. Grandfathering, retroactive zoning laws, amortization periods are reasonable when factors consider 1, the nature of uses, 2, the amount invested in the use, 3, the number of improvements, 4, public detriment, 5, character of surrounding neighborhood, 6, amount of time given to amortize, 7, National Advertising Code versus City of Monterey, should property be fully depreciated by tax code? There's another 2 case examples here, but before I go into that, I'm going to read some of what I wrote in the margin, which is 1, abandonment requires intent, closing for a while is not abandonment, and discontinuation for greater than 2 years equals an abandonment in most jurisdictions. Amortization notes, like side notes, is that is an ordinance providing that a non-conforming use must cease after a time in majority of states, minority disallow as a taking. So here's the additional cases. There was Art Neon Co. versus City and County of Denver, full depreciation not a requirement, and Parkview Associates versus City of New York, a permit erroneously issues for a 31-story building in 19-story zoning could not be allowed under theory of estoppel, good faith inquiry into the existence because doctrine of reasonable due process would uncover an unequivocal limitation. That's just the case. It's not like a rule of law. Except that, like, I guess if you were applying that as a rule of law, you would say if the city allows something that's against its own laws, your company cannot rely on that realistically because the company's on inquiry notice that that would not be proper use for that land. Non-conforming use, a legal use in existence when a zoning ordinance is passed or amended that would be illegal under a new ordinance, but which must be allowed to remain in order to avoid due process or takings claims. So limits that may be placed on non-conforming use is limits on changing the use. Ordinance may provide that use can't be expanded beyond precise space it occupied when the ordinance was enacted. That's the area. Ordinance may provide that non-conforming building may not be rebuilt without conforming to new ordinance. Ordinance may prohibit a change to another non-conforming use. Variances, special exceptions, aka conditional uses, use permitted by the zone ordinance, but only if certain specified conditions are met. Achieving flexibility in zoning, the drawbacks are inefficient patterns of use, inequitable hardship, slow new construction, lower supply, increased cost of housing, deter socially and aesthetically desirable diversity, flexibility devices in following sections, variance of special exceptions, aka special use permit, allows conditional use permit board of adjustment to advance. See note card for conditions and safeguard. So your special use permit, conditional use permit, there's a note card somewhere in another state that I won't be able to see before the bar. Variances. Commons versus Westwood, zoning board adjustment. The facts are that the area size variance needed to construct dwelling on lot that was half as narrow as the neighbor's ordinance requirements, and the variance rejected without cause, for example, stating the purpose behind the ordinance for the denial. What I have written here is departure from the zoning ordinance is applied to a specific lot because of an extreme hardship to the lot owner and not a substantial, my case notes here talk about personal hardship. What I've written in the margin is not a substantial detriment to a or substantial departure from plan or of other lots in the area. Example, Aronson versus Board of Appeals of Stoneham. Existing violation cannot be made basis for furthering violations. Hardship does not include personal infirmity. Self-imposed hardship examples include acid as a disguised use variable. Area can easily be confused as use restriction if, for example, area requirement increase with use. Example, Hertzberg and Pittsburgh group home and commercial zone requires 1,600 square feet. Special exceptions, aka conditional uses, use permitted by the zoning ordinance, but only if certain specified conditions are met. That's your special exception section. It's permitted. Conditional uses permitted by the zoning ordinance, but only if certain specified conditions are met. And a case on point is Cape or Cope versus the inhabitants of the town of Brunswick. The procedural context is in the lower courts in the Supreme Judicial Court of Maine held for Brunswick. And then the Supreme Court reversed. The facts were that the developers appealed from decision of the Superior Court, Cumberland County, affirming decision of Zoning Board of Appeals, denying developers zoning exception to construct 8 multi-unit apartment buildings. And the rule is use by exception may be granted. There starts when, A, B, and C, which are not written in here. So I can't really state the rule. And then analysis distinguishable from Bernard because use by variance permits an owner to use land in a manner otherwise prohibited by the zoning ordinance, whereas a special exception allows an owner to put property to a use that the ordinance expressly permits. Do you hear that thumping?
Yeah, is that him?
He's thumping. He's afraid.
Oh my gosh, James, I thought there was like someone knocking on the ceiling here.
Oh, Bobby.
What's he thumping for?
He's afraid of the dog barking.
No.
Everything's okay. It's all fine. Isn't that sad? Poor baby.
Yeah, I've never heard that before.
I can't see him do it. He only does it under the bed. Aw.
Daddy.
Daddy.
It's like one good thump.
You okay? Okay, so in the analysis, which was distinguishable from Bernard, in the way that the use of by variance permits an owner to use the land in a manner otherwise prohibited by the zoning ordinance, whereas a special exception allows an owner to put property to a use that the ordinance expressly permits. Standards for exceptions must be set to avoid arbitrary decisions by zoning authorities. Holding the Supreme, I feel like I didn't read that at all. So all these conditions that they're placing, they have to be set by, they can't be arbitrary. They have to be set by zoning authorities. The holding here is that the Supreme Judicial Court, Justice Wathrin held that standards in zoning ordinance directing board to base its decisions for granting an exception upon determination of whether proposed use would adversely affect health, safety, or general welfare of a public, and whether use would alter essential characteristics of surrounding property, improperly delegated legislative authority to the board and thus were void. And 2, since the board found that developers were in compliance with all requirements of the ordinance except in valid standards, the developers were entitled to permit for exception. So the court reversed the earlier decision for the city. in favor of the owner. Notes on special exceptions permitted by ordinance but supervised as opposed to variance because of potential noxious effects. Supervision includes hours of operation, parking, location, design, performance standards, and the supervision involves any of these areas to not be adverse to health, safety, general welfare of community. Zoning, I want to say amendment and the spot zoning problem. Spot zoning. Zoning change is typically limited to small plots of land which establish a use classification inconsistent with surrounding uses and create an island of non-conforming use within a larger zone district, and which dramatically reduce the value for uses specific in the zoning ordinance of either the rezoned plot or abutting property. Spot zoning is invalid when a small parcel of land is singled out for special and privileged treatment. The singling out is not in the public interest but for benefits of the landowner, and the action is not in accord with the comprehensive plan. A case on point is Mayo Clinic, State University of Rochester. Facts are that the builder seeks to put luxury condominiums on lot zoned for low-density residential use, situated near single-family homes, and Mayo Clinic complex situated on a lot zoned for institutional use, which is 1 block from and visible to high-rise condos in Central Business District, was 3 blocks away. The City Council approved of the application to rezone to high-density residential use to serve the city's expanding housing requirements. Nonetheless, the neighboring homes appealed the council decision. The issue was the zoning a quasi-judicial act. And they held when a municipality adopts and amends a zoning ordinance, it acts in the legislative capacity under its delegated police powers. The rule is, as a legislative act, a zoning or rezoning classification must be upheld because opponents prove that the classification is unsupported by any rational basis relating to promoting the public health, safety, morals, or general welfare, or that the classification amounts to a taking without just compensation. The conclusion is that the ordinance was upheld. The analysis is that this was a legislative act and is considered to be rational related to the interest in public welfare. The plaintiff must prove that the interest in zoning decision is not reasonably related to public welfare. The plaintiff argument that the condos would disrupt the neighboring uses fell short of that. Notes and questions on spot zoning. There is reverse spot zoning. There's a constitutional aspect. This is reviewed by the rational basis test, and if reasonable minds can differ, then the courts defer. So that's the end of my notes. I guess the last thing on that point is that state action arises. Are zoning boards quasi-judicial, legislative, or adjudicative? Leading to state action. I guess it depends. May not be state action, but I'm going to skip through why zoning, Euclidean zoning, I talked about it. Example of a Euclidean zoning scheme, talked about it. How it includes, I guess at a high level, it includes zoning, use, and what was the last one? Height. Non-conforming use as a definition is a non-conforming use is a legal use in existence when the zoning ordinance is passed or amended that would be illegal under the new ordinance, but which must be allowed to remain in order to avoid due process or takings claims. A lot of examples here. There are limits that can be placed, such as changing the use, expanding the use, rebuilding. And then you have amortization, which is defined as an ordinance provides that a non-conforming use must cease after a certain period of time. The majority view and the minority view. Minority considers amortization unconstitutional as a taking of property without just compensation, but the majority has a little bit of a deeper view that amortization is a reasonable exercise of police power and does not violate due process or the takings clause. However, the period must be reasonable as applied to each particular landowner, and if not reasonable as applied, it is unconstitutional to that landowner. And did I talk about abandonment? Requires an intent to abandon the non-conforming use. Merely closing for a little while is not enough to really discontinue for a certain period of time, like 2 years as a rule of thumb. Variances, the definition is, just a note here, non-conforming uses run with the land and survive a change in ownership. That's interesting. I didn't read that before. Variances is defined as a departure from the zoning ordinance that is applied to a specific lot because of extreme hardship to the lot owner. Granting them follow certain standards. What is extreme hardship and practical difficulty in building on lot? Variance is not allowed. Must not be self-imposed. The conditions must be unique to the lot itself. Substantial detriment must not be a substantial departure from the plan or other lots in the neighborhood. Special exceptions are those conditional uses permitted by the zoning ordinance, but only if certain specified conditions are met. So that's really it. Chapter 13 is about eminent domain and the problem of implicit takings. To introduce the topic, property power allows reallocation of governmentally preferred uses while preventing the government from forcing one private party from bearing the burden that should be shared by all. And the Fifth Amendment about the takings clause reads as follows: nor shall private property be taken for public use without just compensation. The two types are explicit physical taking through eminent domain and implicit regulatory taking where the government can appropriate property, notwithstanding that it had no intent to do so. I just crossed that out. Authorizing permanent physical occupation by a government or a third party. That's more of an explicit physical taking. Example of that case is Loretto versus Teleprompter. It saw a permanent occupation authorized by taking as government as a taking, however little the relevance to public or economic impact of the owner. This was a physical invasion rather than interference arising from program, I think. Adjusting benefits and burdens of public life to promote public good by police power. Nuisance, Nuisance, I'm just going to read it. It kind of comes next, is government action toward private property as a nuisance control is never a taking. So basic difficult. So test government is curing a public bad rather than expropriating a public good. There's the tree fungus case in Miller versus Schoen where the government is requiring these people to remove their trees because they're diseased. And so it's more of curing a public bad rather than appropriating a public good. Couple more cases. Hadachek versus Sebastian. Does ordinance control public harm or create a public benefit? And Penn Central, which is the rule based on measuring and balancing. Get to that on the next page, but first let's go at define eminent domain as the power of government to force transfers of property from owners to itself. U.S. versus Carmack is the pre-existing power. This is a 1946 case of Roman origin. Grotius, Pufendorf, and England for public projects compensation granted. States applied just compensation before SCOTUS ruled. Legislation effectuated, and just compensation motivated possibly by morality concepts of fairness and natural law. Functional justification based on the efficiency from R. Posner. Alternative is for developers to acquire land by using buying agents, option agreements, straw transactions, and deal with holdouts. An eminent domain may be inefficient. However, political incentive, not market incentive, for instance, the fear of government taking may dissuade owners to invest as much in the use. And what is a public use? Like when you go back to, nor shall private property be taken for public use without just compensation. The first question in breaking down takings is, what is a public use? There's a broad view and a narrow view, a majority view. And in Kelo versus City New London, this was a close case. I don't know how they ruled, but there's a bunch of other cases actually after it. Coniston Court versus Village of Hoffman, U.S. versus 564.54 acres of land, U.S. versus Miller. Substitutes facilities doctrine. City was entitled not merely to market value, but to the cost of obtaining or constructing the equivalent of what had been taken. That's U.S. versus 50 acres of land, 1984. It required 3 elements. When the value is ascertainable, the condemnee has duty to replace condemned facility, and the reconstruction exceeds the fair market value. So factor 1, is it a public use? Factor 2, is it explicit, like physical taking? Factor 3, I guess, was it originally private property? Because it says, again, nor shall private property be taken for public use without just compensation. So the fourth factor is what's just compensation. And it's fair market value at the time of the taking. Categories of taking, again, explicit, implicit, regulatory. There is an analysis for explicit taking. Right now, is it taking in public use? Will the government pay just compensation? Implicit taking, does the government legislation lessen the value of the property by too much? And if so, is there a taking even though title remains in the regulated party? And then the regulatory takings questions analyzed. You see 3 of them listed here. Authorizing a permanent physical occupation by a third party. See Loretto versus teleprompter. Abolishing nuisance, how to check. Regulation that takes too much of property value, too much measured against what denominator, problem runs throughout cases that follow. And so Justice Holmes and Brandis in PA Coal Company versus Mahan in 1922 tries to speak to this. There's a lot of, I'm going to cite the cases. The balancing test comes from Penn Central Transport versus City of New York, which applies when the government action amounts to less than total deprivation. Taking all of it is Lucas versus South Carolina Coastal Council, which basically after they bought the property, the government said that there was going to be basically no building here. So that took all of its use, all of its value. What's the denominator again? And that comes from Murr versus Wisconsin, 2017, and personal property, Horn versus Department of Ag, 2015. So exaction is quoted here. Government demand for land or service of in kind or cash equivalent in exchange for approval of permit for projects. There's a Coons case. Looking for an essential nexus, does the demand substantially advance the same interest that the land use authorization assert would allow them to deny, or authority assert would allow them to deny the permit altogether. Exactions are local government measures that require developers to provide land and services in kind, sidewalks, sewers, example, or pay number, called impact fees as a condition to getting project approval. Property taxes, government granting make up the difference, substitute other services in kind and impact fees. Nolan versus CA Coastal Commission 1987, the state couldn't condition a public right-of-way upon the petitioner who was seeking a permit to build a house that would interfere with the view of the beach, held there was no essential nexus, i.e. roughly proportionate taking to ask because the public could still get to the county park without the access that was being asked for. In Doolin versus City of Tigard, roughly proportionality test, the test requirements still not roughly proportional because the bike and walking path not evidence as a solution to a traffic problem caused, and the dedication of land is not helpful for flood concern caused by parking lot or shop size causing runoff. So both in nature and extent to the impact of the proposed development. That probably has something to do with the definition of roughly proportional. Explicit taking analysis. Government takes either fee simple or other interest. Example, when an easement amounts to a flooding, when there is no question that there is a taking. Public use, two views. Broad view has been accepted by SCOTUS and Kelo versus City of New London. The public purpose coterminous with the scope of the sovereign police powers. Economic development with police powers. O'Connor view is that this is too broad and they want a more narrow view. Will government pay JC just compensation? That's the end of the explicit taking analysis. So it's like, I guess it's a 5-part. Government takes, amounts to a taking, no question there's a taking, is it for public use, and was there just compensation? According to the broad view, and was there just compensation? For regulatory taking, which is implicit, the analysis is there a taking at all? Has the government regulation lessened the value too much? If there is government, if so, the government must pay just compensation to rescind the action. The question of public use really comes up. May back pay for just compensation before rescinding. PA Coal versus Mahan. Kohler Act prevents change from mining land he contracted for with private property. A private party defendant argued that the legislation acted as a taking without just compensation, as an interference with his right to contract without due process. Defendant prevailed. The Kohler Act invalidated as a taking. So it had to do with like how much you can subsist of the land by coal mining. The legislation put in place was taking to the party that had a right to extract coal. And the dissent views it as a permissible police power, safety, health, and morals to abate a nuisance. The Keystone Bituminous Coal Association versus Benediction of 1987 reversed Mahan. And then the Penn Central Transportation Co. versus City of New York ad hoc factual inquiries together form a multi-factor balancing test. I've got 5 parts written here. The economic impact of a regulation on the complainant. For example, a percentage of value, a diminution of value, extent of the interference of the property owners, investment-backed expectations, the character of the government action, physical invasion or permanent occupation for FYI decided before Loretto, action aimed at preventing noxious property uses, below common law nuisance, and if an average reciprocity of advantage, if regulatory destroy to recognize property rights. And then I wrote TDRs, triple debt restructuring. I don't know what TDR. Recipients of TDRs may sell their rights to use them and land they own in an a transfer asset to case burden of land use restriction by providing some form of compensation. And what have I written in the margin? Used to analyze a regulatory taking when the government action does not amount to a total deprivation. Inverse condemnation: a claimant rather than the government institutes a suit claiming that a taking has occurred and seeking recompense for it. A forced purchase rather than a forced sale is the objective. There's a Tucker Act, which is another categorical rule. All value avoidance, no expectations. Regulation deprives owner of all economically beneficial or productive use of land there is a taking, requiring just compensation, unless the regulation does no more than abate a nuisance. But altered nuisance exception coming from the Lucas versus South Carolina Council, pre-enactment acquisition that have the effect of a total deprivation of value. Going back to the altered nuisance exception, legislative judgments of harm are not legitimate, but made judgments are legitimate. Transfers of authority, for example, nuisance must be a civil nuisance as recognized and applicable in the state, and rejects Lucas by holding that any new regulation, once enacted, becomes a background principle of property law which cannot be challenged by those who acquire title after enactment. The next case is Tahoe Sierra Preservation Council versus Tahoe Regional Planning Agency of 2002, involving a moratorium that prohibited virtually all development on designated property for almost 3 years. Petitioners argued conceptual severance, rejected temporary deprivation of economic beneficial use, but SCOTUS denies conceptual severance and requires permanent total deprivation of economic beneficial use. The elements of the next case, Murr versus Wisconsin, are here for answering what is too much. I've got XYZ elements. XYZ. See elements on page 80. So I'm just going to scroll to page 80 here because maybe that's the secret. Here's 80. XYZ. Value of property under challenge regulation will, with special attention to the effect of the burdened land on other holdings, physical characteristics of the land, including physical relationship of distinguishable tracts, and last, courts must give substantial weight to treatment of land, in particular how it's bounded and divided under state law. Those are the factors from Murr. That said, the courts must give substantial weight to treatment of land, in particular how it's bounded and divided under state law. That was one of them. Physical characteristics of the land, including physical relationship of distinguishable tracts, value of the property under challenge regulation, with special attention to the effect of the burdened land on other holdings. Now, I'm on page 71. I'm fairly sure that the next bit that I'm going to go into is just broken into or referred to as class notes. So there really shouldn't be anything new that I haven't already said. Let's hope. But just before that, the book had gone into takings of personal property rendered economically worthless by the government measures. An example is Nixon versus U.S. Nixon could sue for presidential papers because he had a compensable property interest in the court allowed papers to be subject to takings per Lucas interpretation. Another case was Horn versus Department of Ag. So then again, just a reminder, nor shall private property be taken for public use without just compensation. What's private property? What's just compensation? What's public use? Again, what is just compensation? Fair market value at the time of the taking. Fair market value is the price a willing buyer would pay in cash to a willing seller, usually determined by experts in a relevant market, often the most litigated issue in explicit takings cases. No constitutional right to a jury trial, except in California. Well, that's news. Need only pay fair market value even if the state must replace the facility and cost of replacement exceeds the fair market value. The categories of takings are explicit, implicit, / which means regulatory. So that's exactly what we went through. So abatement, abolishing a nuisance is never a taking. From Hadachek versus Sebastian, remember that Loretto versus Teleprompter Manhattan CATV Corp is the permanent physical occupation by a third non-government party. Let me go over in my class notes the same stuff. In fact, I've crossed most of it out. Maybe just look it up. Categories of takings, explicit takings, implicit takings. Jeez, this is duplicated like a third time. Exactions again, the definition is a government demand for land or services in kind or cash equivalents in exchange for approval of project must have an essential nexus, which is a direct relationship to their public interest, and which must be a reason for the denial of the imposed development or proposed development. So you need an essential nexus, advancing the same interest that land use authorities assert to deny a permit altogether. Now, I didn't really define the narrow versus broad view of public use. Narrow is public use is established by either public ownership, roads, courthouses, schools, or use by public, which may be for a fee, railroads, mills, sports stadiums, as long as the use is not restricted. The broad view, on the other hand, is public use established if taking is for a public purpose, even if the property is transferred from one private party to another. I wrote Merck in Kilo case, reinvesting, revitalization. And then there's public use, O'Connor's opinion from Kilo. And all of this is essentially duplicative. Conceptual severance, one of the terms that I used. In Pennsylvania Coal versus Mahane, while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as taking. According to Holmes, the regulation abolished all of what the state of Pennsylvania recognizes as a separate estate in land, the support of the surface, So the denominator is the coal supporting the surface. Brandis, on the other hand, the regulation only restricts the coal company from mining a small portion of all the coal that it owns. The denominator is the full extent of the coal company's coal. Because we're trying to identify what is the denominator in the, quote, too much formula. Taking too much of the value. Penn Central, your regulation deprives us of all air rights above the current height in Grand Central Station. The denominator is the air rights. The majority need to look at the value of the city tax block. That is a landmark site. The denominator is all of the city's tax block. And the denominator problem from Lucas is regulation requiring landowner to leave 90% of rural tract of undeveloped natural state. Landowner regulation deprives me of all burden portion of the tract. And the denominator is the undeveloped portion. You suffer diminution in value of the entire tract. You can still develop the other 10% of the tract. And the denominator, according to the state, was the entire tract. So that's how they're defining denominator. And I checked all this stuff off in the next section because I think it's already been said. Taking is more regularly found when there's a physical lesion rather than interference arising from a program adjusting benefits and burdens of public life to promote public good, which is an exercise of the police power. And I'm going to say this is it because I already read the MER elements a couple times. There's 3. Can I sum them up even more than the wordiness that they are? Substantial weight to treatment of land, in particular how it's bounded, the physical characteristics, what's distinguishable about tracts, and the value of the property under the challenge regulation, with special attention to the effect of burden land on other holdings. That is it for real estate. My outline from the second half of the semester.